It is Saturday, April 4th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today's compilation is a wild ride through the justice system, spanning 4 days of intense hearings. We kick things off on March 30th with Judge Stillwell handling a chaotic protection order hearing. Then on March 31st, Judge Stevens loses it over a filmed barbershop assault. We also have an April 1st lineup from Judge DiSanto where an attorney flat out quits in the middle of his hearing, and we wrap things up with an April 2nd rapid fire compilation from Judge Simpson. Grab your snacks and buckle up, ladies and gentlemen. These defendants are learning the hard way that excuses don't fly even on Easter week. And it all starts right now.
That leaves us with Amanda Maddox and Creona Mott. And folks, are you here with Miss Maddox? Okay, everyone's here. All right. All right, Miss Mott, I see you on Zoom. Right.
Yes, hello.
Hello. All right, good morning, Miss Maddox.
Good morning.
All right, give me a moment while I bring up your case. All right. So I know you all have been here now for a couple of hearings, and so you sort of understand. You'll have an opportunity to testify. I may have some questions that I'll come in and ask as we go, and so with that, I've reviewed the file. I have a few questions off the bat, but I don't think anything sort of material enough to have you address up front. Instead, what I'll just note is for both of you, Ms. Mott and Ms. Maddox, I have reviewed everything, all the exhibits, everything to that nature, so you can be confident that I've read everything. And so there's not necessarily a need to go over the individual text threads and things of that nature. If you want to keep it a bit more bird's eye level, that would be helpful. And with that, though, Ms. Maddox, if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes, sir.
Okay, go ahead, ma'am.
I would like to clarify. I had an issue with seeing a response from Ms. Mott, and I had been checking daily. So thankfully, when I contacted TCDC on Friday, they were able to file a response. Were you able to see that and consider that? I have it here and will happily read it. It's pretty crucial to her response, I guess.
Let's see. Let's see. This was on the 27th.
Yes, sir.
Yeah.
There was a misunderstanding on the case number, and I didn't understand how the system looked, so it kept showing no results found, but there was a missing 6.
Okay. All right. I do have that up. Ms. Mott, were you able to view what was filed on Friday?
No. I got served just the harassment order that she wants through Facebook Messenger. I think it was like a week ago. Exactly.
Right. Yeah. So the service packet includes how to view documents that are subsequently uploaded. Let's see, but you haven't had a chance since Friday to look at the to look at the court file?
No.
All right. And I haven't either. I have it in front of me. Miss Maddox, what I'll do is read it here briefly. And then I think if it seems like this is in line with kind of testimony, kind of summarizing the issues, then I think we're okay. If it raises any new issues or anything to that extent, where it seems like maybe Ms. Mott should have the benefit of a little bit more time to read this before, being able to respond, then we can talk about, maybe a reset or something like that. So what I'll do is I'll take a look at this first. It looks like it's about 2.5 pages. So I'm going to take a look at this, see if it's appropriate to move forward today. And if so, I think maybe it would make sense for you to read it into the record, so Ms. Mott can hear it. But again, if it raises new issues, then maybe we can talk about how to move forward here. So I'm going to take a few moments and read this. And Ms. Mott, it is up in the court file. So if you're able to access the court file, looks like it has been up there since Friday.
Yeah, I only get on my phone. I don't have a laptop or a computer, so I tried to understand what she served me as best as I could through my phone.
Okay.
But
all right.
I'm good with her reading it.
Understood. All right. I'm just going to take a moment here and read what was filed. All right. So what I'll do. So Ms. Maddox. Well, I guess this is more for you, Ms. Mott. What she filed on Friday is what I view as tantamount to written testimony in response to the materials that you provided in your response. And so there's nothing new here that I think warrants resetting the case. Instead, what I'll have us do here is I'll have Ms. Maddox kind of read what she has here. Looks like that's printed out. Is that right?
Yes, sir.
Yeah, so I'll have her read it out. Again, this is really more testimony that's responsive to what Ms. Mott, what you submitted. So you'll have the benefit of that response in the form of her testimony. And then after Ms. Maddox provides her testimony, Ms. Mott, you'll have a chance to reply. Okay. And so we'll go from there. I do want to preface this a bit with saying I understand it's going to be difficult, so I'm going to give some leeway here. This is not necessarily about the prosecution of Michael Mansfield and what may have happened here. This is a request to prohibit communication by Ms. Mott to Ms. Maddox. I understand it's impossible to separate the issues with Mr. Mansfield with what's the petition here. So again, I'm gonna let some leeway there. But to the extent we start getting into some of the substance of the allegations against Mr. Mansfield and things of that nature, I'll try to keep us more on course here. Again, recognizing that these are all very related. But just try to keep that in mind as best you can, ma'am. All right. And so with that, I've sworn you in. And go ahead, Ms. Maddox, with your testimony.
I am writing this today to address Kriana Mott's response to my request for an anti-harassment order. I was unable to see that she responded until March 27, 2026, due to putting the wrong case number into the link that was sent by TCDC. The subject line had 26-00006 instead of 26-00066, which showed the filings. I was unaware that this was the issue until contacting TCDC. I was checking daily since Kriana was served, but it kept coming up as no results found. I am attaching a screenshot to hopefully show the court the misunderstanding on my part and confusion of case numbers. I will be ready to proceed March 30th at 9 a.m. if the court can take this response into consideration. If not, I request the court give a continuance so it can be considered. The statement is crucial to the case. Kriana and I did have a good relationship as long as I was attempting to get Michael out of trouble. I won't deny that. I also won't deny that I struggled with sobriety after Michael started abusing me again. I have remained sober since he was arrested the second time in January because I no longer have to live in fear. I had been sober for just over a year when I relapsed on July 11th, 2025. That night, Michael choke slammed me into the ground out of frustration and the abuse cycle began again. Kriana witnessed him do this, and instead of standing up for what is right, she gave me one of her Valiums so I calmed down from the pain and sleep. Kriana mentions my drinking several times, but fails to mention her own dependence to benzodiazepines and marijuana. Michael's last use of methamphetamines was in October 2025, when he abandoned my son and I without any money or food in the home for 3 days. He did this again in January, which is why I was so upset in the messages to Kriana. Michael had been unfaithful for the entirety of our relationship, exposing me to STDs throughout my pregnancy, in which I had to receive treatment. And the messages were in reference to him choosing women over us again. He had done this many times prior. I was very upset and heartbroken because I was attempting to get him out of trouble for strangling me, yet he continued to seek out other women. I was also free to express my anger in text messages because I couldn't do so in person without the threat of being hurt. I expressed anger and hurt with words after years of abuse and control. Both her and Michael both have extensive assault convictions, whereas I have none. She put a woman in the hospital for talking poorly about her daughter and served time. I was very aware of her past violence and could only express myself via text messages. It was a nightmare situation, and I am truly grateful to be free. I just finished an intensive outpatient program and am continuing on my own healing journey with multiple forms of therapy. Kriana states I stayed away for 4 days in July. In actuality, I was kicked out of the house and not allowed to return. I was arrested on July 14th for an unpaid bar tab. This case has been dismissed because it was linked to Michael's financial abuse. I had money in our account, but he had taken all of it, once again leaving me homeless and without anything. This had occurred multiple times within our relationship, including me sleeping in my vehicle while 7 months pregnant for 2 days. When we were living off of my salary and then maternity pay, it was our money, but when he had money, it was his, strictly his. Thankfully, the state was able to see I was being financially abused as well as emotionally, mentally, sexually, and physically. Kriana states that someone else is caring for my son. I am my son's primary caregiver, and this can be verified by the individuals who are in court with me today. They watch him if I have appointments or meetings, but I am his safe place and support. I know without a doubt that the individual who was attempting to serve Kriana was at the right house and was able to describe Kriana's vehicle precisely. We verified over the phone and through pictures. Casey's statement seems to be a lie to assist Kriana, or she needs to have her security cameras checked for inaccuracy. Kriana's statement of events that allegedly occurred on January 4th, 2026 is completely falsified. If any of those things are true, Kriana would be able to supply a police report number, picture evidence, and domestic violence is taken very seriously in this state. I would have been arrested. More importantly, Kriana did not come over on January 4th. I did drink again the night of January 3rd when they had taken my son after 3 months of sobriety, which I admitted to in the text Kriana submitted. Michael would take him as a means of control and to trigger a response out of me. The conditions I was living in after the strangulation up until I was finally free of him are some of the darkest, most confusing times of my life. I did want to help get Michael out of trouble because I still cared about him. And he told me that I had to get him out of trouble or he'd take my son from me forever. I am now in therapy to help overcome battered woman syndrome. I never yelled at my son about his father or threw anything at Kriana. This is a perfect example why I am seeking protection from Kriana. She will say and do anything to make me seem like the aggressor. Kriana states she wishes me no harm, yet lies and makes outrageous accusations to support her in Michael's case. She was not over on the 4th of January at all and cannot supply any evidence of this allegation. I hope the court sees what she is attempting to do. I knew there would be retaliation for me seeking this order, but had no idea the depth she would go to create more issues. Also, there was no welfare check on January 4th and no record of this. If I were drunk and throwing things, why would they have left Bodie with me? Also, if this were true, why was she back at the house on the 7th with me? Nothing from this allegation makes sense, and she has no evidence besides her statement. She sent welfare checks out of retaliation after he was arrested on January 10th, in which I have provided the court with the sequence number to confirm this in my previous filing. I would also guess that if she did file a police report, that it was done after he was arrested, again, out of retaliation. The text messages on January 5th, where I stated I was embarrassed of my behavior, is in reference to me posting about Michael's abuse on Facebook and speaking so poorly about Michael via text to Kriana, which you can see me talking about as the messages progress. My child had been taken from me, I had relapsed and was seeking help so I could reestablish myself, which is why I wrote a statement asking him to sign. You can see the desperation in my statement of him not having Bodie around other women because that is what Michael was doing prior, taking him and exposing him to other women without my knowledge. I was also terrified he would remove him from Thurston County because his mother and him had made threats to hide him in Forks, Washington. The individual in court can also attest to these threats. I needed help and could not go get it due to their intentions and the fear of what would happen to my son. I initially sought this order to protect myself from harassment and pressure to not cooperate in the case against Michael. After seeing these allegations, I now feel it is more important than ever that this order be enforced. She is willing to use any form of abuse to save Michael's reputation and support his violence. The police reports demonstrate I was left with markings consistent with strangulation. There is CCTV evidence of him dragging me by my hair in the hallway, and evidence of his severe alcohol use at Great Wolf Lodge the morning of the attack. I am fearful of what other allegations she will attempt as this case continues, and I do not believe she will be able to restrain herself. She supports and encourages Michael's violence. She told me many stories of the violence she endured by his father, and it is sad that she had to go through that, but that does not make it normal or acceptable. Brianna states she wants to restore peace, yet makes such extreme accusations and turns quickly if things are not being done the way she wants them. I would love for us to get to a place of peace eventually, but I do not believe that that can happen at this time. She wants to justify Michael's abuse, and the only way to do that is to make me look unstable and incapable of caring for my son. She also states she just wanted to see if Bodie needed anything, yet neither she nor Michael have provided any financial or essential needs for Bodie. I know for myself the hurt and pain caused by Michael is far too fresh and will take me years of therapy to undo the abuse I endured for so long. If she could refrain from trying to justify his actions, we could have a relationship, but her messages from February demonstrate that we are not there yet. And there was 2 or 3 other quick things I wanted to point out, if that was okay.
Sure.
In the text with the Amber individual, when she was addressing something about the CPS situation or possibly calling CPS, that was not what was relayed to me, and those individuals are in court with me today. But you can see where she's talking about I'm going to get picked up that day. After Michael was arrested the first time, she was doing everything to get me arrested, anything and everything. She also conveniently cut out me talking about the fear that I was in the October text. That conversation wasn't finished, but I wasn't able to supply those. And when she would come over to the house, the day that I mentioned in my initial filing about where she was being particularly nasty to me, I wondered why she was. And when I looked down, she had her phone positioned in her pocket in a suspicious way, as if I were being recorded. And I sensed that she was trying to get a reaction out of me. And lastly, I want to say this situation is chaotic and messy and heartbreaking, but I did not seek protection against my son, against Kriana, or his father. I have graciously and actively tried to have him see him against all odds, because I don't want to do that to my boy or to him or to her. We have court-appointed mediators that Kriana was going through, but on February 20th, she didn't like the stipulations that her son was under. So that's why she went around and found contact with me. And this was after I had changed my number, where I live, what I drove. I mean, I changed everything about my life because after years of leaving and going back and leaving and going back, I was finally free of this.
Is Ms. Mott a party to any of those other orders involving Bodie and all of that? Or is that just between you and Michael?
No, she's not a part of it.
She's not a party to it?
No.
Okay. All right.
No, and she was not present at Great Wolf Lodge when the strangulation occurred.
Thank you.
Yes. I think that's it.
All right. All right. Ms. Mott?
Yes,
If you please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
yes, I do.
Go ahead, ma'am.
I'm not a part of Mike and hers fight. I wasn't there at Great Wolf Lodge. Sorry, I can't say that correctly. I've never condoned what has happened. I wasn't there. I don't know. They both have different stories. I've always been there to help with, just to help with Bodie. I think they're both irresponsible. Amanda's not telling the truth. I've never threatened her. I've asked to see Bodie numerous times since January and have been told no. I have offered to buy diapers through Jan and Mike Davenport, and they said no. When my Amanda was struggling to stay sober, and we had Bodie, I took him over there to see her twice. We never tried to keep him from her. I even had the Davenports take him there, but they called and immediately had me come back and pick him up because Amanda was not in a good frame of mind. In the texts that I provided, I could have provided you a booklet. I have kept everything since she was 3 months pregnant because of her inconsistency and not being able to stay sober. I have never wished her ill will. I have always forgiven her for sending not nice messages or horrible texts. She sends them to, when she gets drunk, she sends them to my mom, my other siblings, or my other children. And all of that will come out when they go to court, because I'm going to have to be one of Mike's witnesses. But their fight is between them, I'm not in it. I'm only there to help with Bodie. I've never reached out and harassed her. She did get a new rig, I heard, but hers was not running. It's not like she's trying to change her whole identity, so nobody, like, we're chasing her down or I'm chasing her down. I did stay, when I come there, I've stayed twice with Tacey, her name is, and she did go through her whole surveillance camera. Not one person has been there to try to serve me. I was only there for 4 days, the beginning of March. And I have a silver Charger, and she has a silver Honda that sits in her driveway 24/7. She drives a truck to work, so I don't know if they thought that was my car. But I just don't feel like I need a harassment order placed against me. I don't reach out to her. And when I did, it was to see if her and Bodie needed anything. I've always tried to be there for her as much as I have been with Mike. I've even went to family court with her for her trying to see her other 2 children. I just don't wish her any ill will. My main concern is about Bodie. And I miss him terribly. She doesn't let me, I mean, I went from watching him and having him all the time to not being allowed to see him, or I'm not allowed to have pictures of him anymore. And I do miss the little guy. He's an amazing little boy. And I hope that one day that this will pass and that peace can be restored. But she has nothing to worry about me trying to harass her or track her down. I don't know where she lives. I mean, I know she lives with Debbie, and I like that because Debbie takes good care of Bodie. And when Amanda's drinking, I just feel like she gets wrapped up in her sadness and things that have happened to her in the past. And maybe she doesn't prioritize him when she's hurting. I don't
Thank you.
know what to say.
All right. Ms. Maddox, back to you. You mentioned in your petition, as well as your testimony, that you are not trying to have Bodie be a part of the protection order between you and Ms. Mott. So can you talk to me a little bit about how you would envision that? Like, let's say the court were to enter an order. Would you, how do you envision that going forward? If Ms. Mott's unable to speak with you, are you still comfortable with that happening as far as her seeing Bodie, or and I ask because it seems like you've been explicit about wanting to not have Bodie involved in any kind of protection orders. And from a lot of the text messages that both parties have filed, it seems like a lot of the communication does revolve around Bodie. And obviously a lot of emotion around him as well. So how do you envision that working were the court to impose an order?
We would use the court-approved mediators,
Okay.
which is who we've been in communication with. And I did tell them that his size of diapers and everything. So I need help financially until I find work and resourcefully. So I'm not sure where the miscommunication on that part is, but I also told them that I needed a car seat for him, that I needed new shoes for him, that he's outgrowing things. And so I'm not sure where that miscommunication has happened.
All right. And
And
so the
nobody
mediator
knows
is that what all right. In one moment, Ms. Mott. So can you talk to me a little bit more about the mediator and what that situation is?
Yeah, so we wanted to keep this out of family court.
When you say this, is it a separation or divorce proceeding between you and Michael?
We're
or
unmarried.
Okay.
So we're unmarried, and I have been through family court. I think it's a beast,
Mhm.
and I didn't want to have to do that again for myself or with Michael. I have struggled with sobriety. Being in an abusive relationship made it extremely difficult. Again, seeking therapy and all my healing on these parts. But with his upcoming trial and with the history of them taking, and I do have to say them because she was a part of this, them taking Bodie, whether I was drinking or not drinking, it was a punishment to me. And when all of this happened on January 3rd, I had just done an interview recanting. So it felt like I was doing all of these things to save him, and I was still being punished, and my child was being taken from me. And it's my responsibility that my reaction is to drink. But again, I'm not living in that anymore. That's not my life anymore.
So is it a mediator? Is it a
Oh, I'm
mediator
sorry.
for? No, it's
I
okay.
deviated.
That's part of my job.
Yes.
So is it a mediator for a parenting plan then?
Essentially, we weren't doing anything through court.
Oh, I see.
I spoke with the prosecutor, and he asked me, he was like, is it okay if these individuals are allowed to talk to you about the child so that information could be conveyed to him, and also then his mother through Michael. And I send pictures. There hasn't been any updates. He does have a doctor's appointment this week. I would have sent an update then. So we got it. I had it cleared with the prosecutor and with Michael's attorney that these were safe people to go through, and Kriana had been using them prior to the 20th of February.
Okay. All right. So through Michael's prosecution,
Yes.
there are some third parties who've been identified that allow some communication.
Yes, and so that he
regarding
wouldn't get in
voting.
trouble.
I see. Okay. Got it. Thank you for clarifying that. All right.
Sorry for
And are we talking about the Davenports?
Yes.
Okay, and that's the ones that when we did have Bodie, when you were drinking that, I gave Bodie
So
to
Ms.
them.
Mott-
to
Ms.
bring
Mott-
to you.
So that's an example of, you address the court. All right. So if you want to respond to something, don't say you when you're talking to the other party, talk to me.
Well, and
Right.
that was the Davenports are the ones that I have asked if he needs anything, and Jan didn't respond back to me. And then it was like a week later, I got served those papers, and I reached out to her and I said, hey, I'm sorry for asking if Bodie needed anything. I didn't know that I had a harassment order trying to be served on me. And she just, texted me back that the whole situation was just heartbreaking.
And I did inform the Davenports after the filing because I did not want Kriana to unintentionally break it. And so we could also arrange for her to talk to the Davenports about Bodie. But one of the bigger, broader issues here is Kriana constantly inserting herself into this situation where she could easily go through her son, who is allowed to go through the Davenports.
Okay. All right. All right. Thank you. I know, Ms. Maddox, you've been providing some follow-up testimony. It's your petition. It's your burden. So if there's some concluding remarks you'd like to make, now's your time.
Are you speaking to me?
No, I'm sorry. I'll try to speak up. I'm talking to Miss Maddox.
Oh, okay, sorry.
Spot.
I believe that eventually we can get to a place where there will be peace and reconciliation. For me, it is extremely distressing to hear from Kriana because her history is now backed with her trying to interfere with the justice system. And I'm learning a lot about how abused women behave. And she was just a part of that. She was a part of me lying to get him out of trouble. And the focus is going to all be put on my drinking and not on the violence that I was enduring. It's not appropriate for me to be in communication with her. And the larger threat now that I have is these accusations that are coming out. I'm growing and living my life and trying to heal. And I've now had welfare checks. I've had CPS, I guess it ended up not being, but there's been threats overall. And it affects my well-being, which affects my entire life, my ability to parent. And I thought, well, I actually had reached out to the prosecutor that it was kind of just like putting the situation on ice. That way there could be no contact from her, pressuring me to cooperate, or because in her earlier messages, so she said he's doing so well and he's wonderful. And it's very raw for me. I'm still trying to move on past this relationship and all the damage. And I understand she's trying to save her son. I sympathize. It's just not appropriate. It's not safe. I am on my own journey now. I think that's it. I know that she cares about her grandson. I do. And I hope we can find a safe way to make that happen. But for me, as the party that was isolated, living with those two and trying to get him out of trouble, it's not safe for me mentally, emotionally. I can't do it.
Thank you, Ms. Maddox. All right. Well, before I make my ruling, I want to thank you both for being here and addressing what is clearly a very difficult situation. Apart from there's this prosecution happening with Michael, and this is just another court proceeding, and so I realize this is difficult for everybody. I am going to grant the order as requested by Ms. Maddox. The reason being is Ms. Mott, I understand what you've been saying about the reasons for interacting with Ms. Maddox, and wanting to focus on Bodie and all of these other things. What I'm looking at in the anti-harassment statute, and I said this earlier this morning too, is when the court is looking at whether certain types of communication meets the definition of unlawful harassment. One of the things that we look at, and this is really what I'm basing my decision on, is whether the respondent's course of conduct has the effect of creating an intimidating, hostile, or offensive living environment for the petitioner. And so, in this case, I think that Ms. Maddox has met her burden in showing that, for whatever reason underlying the communication from you, I feel that it is having that effect on her. And so, for that reason, I am entering an order. It is just, again, between the two of you. It is not involving Bodie. And what I'm also going to do to just make sure that there's no miscommunication and sort of accidental, unintentional violations, I'm gonna put in the order that there's, I'm going to call it an exception, but hopefully it's just more of a clarification that third-party communications related to, and I'm going to put the cause numbers for the Superior Court cases involving Mike, that's okay. Is that?
Yes.
So that if the mediators in the prosecution case, there may be a situation where Mike wants to talk about Bodie, and Ms. Mott and that involves some communication from her getting to you through a mediator. It sounds like that's not what you're asking to be prohibited, so long as it goes through those mediators. So I'm going to carve that out as well. But other than that, the order will prohibit contact between Miss Mott. Well, it will restrain Miss Mott from contacting Miss Maddox in any other way. It's going to be in place for a year. I understand it is at this point longer than the trials that are scheduled in Mr. Manfield's case. So just be aware that if Mr. Manfield's, if his case resolves in any pretrial mediators or anything to that extent, that kind of goes away with the case. That will have the effect of then taking out that exception, if that makes sense. So right now there's that third party communication exception related to a prosecution that at this point, if my notes are correct, is scheduled for trial in late May and early June. So whenever that prosecution resolves for those two cases, if it resolves before this order resolves, that exception will go away. Does that make sense, Ms. Mott?
Oh, I have a question. I mean, I want to know, like, how was that going through? I mean, how did I harass her? I don't understand that. I was never a witness to them fighting. I mean, I really don't understand how this is being approved. I've never harassed her. I never witnessed them being violent.
Ms. Mott, I'll answer your question. I want to make sure I'm clear in how I got to my decision. All right. So the basis of the order is are the text messages between the two of you, the two of you being the petitioner, Ms. Maddox, and yourself, and some testimony today on talking about the case. I'm really not talking about communication between, or I'm not looking at communication between the two of you, talking about Bodie and updates on Bodie and things like that. There are some text messages that have been uploaded that indicate some discussion about Miss Maddox's relationship with Mr. Mansfield and talking about the outcome of the case. And again, I'm not, this isn't to say that you are having the, it is the purpose of your communication to, intimidate or do anything of that nature. It is having the effect on Miss Maddox of feeling intimidated with respect to how this case against Mr. Mansfield is going forward. That does meet the definition of unlawful harassment.
But I only got involved when she asked for my help. I mean, that's the only reason, and that's one of the texts is she asked for my help.
Right, and it sounds like this has been a very right. Understood. And communication can change, right? There's a lot of dynamic back and forth that has happened here. And again, as I talked about earlier, one of the ways that we usually look at these things is there persistent communication after being told to stop? That's one way we look at this. Another way we look at this, though, is what is the effect of that communication having on the petitioner? And if it meets that level of creating an intimidating or hostile or effect on the petitioner that's causing substantial emotional distress, then that does meet the definition of unlawful harassment. And based on the text I've seen about the case itself, I understand there's also conversations about help with Bodie. We're not talking about those. We're talking about the conversations with respect to the case against Michael. And based on those and Ms. Maddox's testimony on how that is having an effect on her, I am finding that meets the definition of unlawful harassment.
Well, not to be disrespectful, but I think that's wrong. I just totally think that's wrong. She has asked for my help to try to fix what is going on between them, even though I was not there. She asked me to go to court to help get a judge to sign off on the harassment or protection when it first started. I mean, I will totally abide by whatever you say or that you've granted, but that's not true, and that's not how it happened. I only was there to help, and it was because she's the one who reached out for me to help.
I understand, Ms. Mott. And I understand that you disagree with this. I understand that. The order is going into effect. Again, it will be in effect for a year. Reconciliation happens in the future. We'll see what happens in a year with this order. But for now, again, communication through the mediators, so long as they're in place, is allowable. I am putting that exception in here. But as far as communication directly between, or any communication between Ms. Maddox, I'm sorry, from Ms. Mott to Ms. Maddox, outside of that context is prohibited for the next year.
And there hasn't been any, so that's fine.
Okay. All right. All right. Thank you, Ms. Mott. You're free to go, ma'am.
You are, sir. Javion Johnson. Is here with Mr. Dusler, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? In summary, this indictment alleges in 25 CR 1773 that on or about October 30th, 2025, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault, causing serious bodily injuries to another person. Do you understand what you're charged with today? You understand?
Yes, sir.
This is a second-degree felony which carries with it a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached where you would be pleading guilty. Placed on, but not found guilty. You would be placed on deferred or unadjudicated probation up to 10 years in length, fined $500, ordered to pay restitution, which is how much?
$47,540.03.
$47,000.
$540.03.
It's a lot of restitution.
That's fine stuff. Ain't new on them.
You're kidding me. Are you in a gang or something? Is that what you do?
No, sir. So that's the motion response.
So why did this occur? I'm talking to you,
It was the incident.
huh?
It was the incident.
I can't hear
It
you.
was the incident.
What'd you say?
It was the incident. Accident.
It was an incident.
Yes.
Is that your answer to that question? In this town, this is what you're doing? He's just waiting to get a haircut and you walk in, punch him and say,
The co-defendant punched him. He was, my client was videotaping. That's how it's not, now it's way.
okay, so this is under the law parties that he's here?
Yes.
Okay, so you're working with him. This is, so this is on a video. You just walk in.
Yeah.
A person just sitting there waiting to get a haircut and he gets pummeled. And then you're on a video saying, this is the type of shit we do, roll up on niggas at the goddamn barbershop in this city? Are you kidding me? In this city? People, I mean, what kind of irresponsible behavior is that? And then the vulgarity. Do you find that odd, what you did?
Yes, sir.
We don't put up with this in this town. And first of all, you start using the English language, not trash talk. That didn't get anybody anywhere. Look, I prosecuted the James Byrd murders. I don't put up with this. This is just vulgarity and it's bigotry. And it's not sophisticated thinking. You understand?
Yes, sir.
What did we do with the other guy that was beating? Is he being prosecuted?
I have to look and see.
I think it's still,
the
I
case.
think it's still pending.
Don't know if it's even assigned to me, but I have to look.
Does, Davy and Thomas is, I think is who it is. That's who it is. Davy.
Thanks. Yes. Maybe why
It is aggravated assaults in broad daylight in a business where people are just trying to take care of their needs. And then y'all just walk up. That's your plan. You walk in and just start beating people senseless and then bragging about it.
Co-defendant is set for his initial setting on the 15th of April.
Here,
Yes, sir.
that should be interesting. You better fix this. You understand?
Yes, sir.
Don't do anything like this again. Act responsibly. But follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
This is what this city stands for. In this county, we're better than this. How do you plead in this? Guilty or not guilty? Talking to you.
Yes.
Are you pleading guilty voluntarily and because you are guilty of what this alleges?
Yes, sir.
Hmm?
Yes, sir.
Sir?
Yes, sir.
Okay. And do you understand? I'm sure Mr. Dusser, he's a very smart man, talked to you about, you don't have to do the punching. You can be part of the whole fracas. And videoing it is obvious y'all are working together. But when you know something is going to happen and you help or take part in it, you are held just as responsible as the person who's punching. You understand?
Yes.
So fix this. I'll show you what's marked as State's Exhibit 1. Did you sign that?
Yes, sir.
Voluntarily, understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 is tendered into evidence without objection. It's admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1 is made a part of the record for all purposes. Please answer for what?
Yes, sir.
Anything else to add?
Yeah.
If nothing further, I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, although this is a rare type of set of circumstances. You must pay a fine of $500. Restitution will be owed. This is a total amount of restitution
That is the
in this event
Yes.
of $47,540.03. I intend for that to be shared between the two parties, but we're going to see what happens on the other case. You are responsible for the full amount as well as the other person. And what generally we do is when there's two people involved, they share the responsibility. But the law states both of you are responsible for the full amount to be paid however, both of you can pay it, but the total amount is $47,540.03 from the injuries, I guess, occurred. That's a pump. That's terrible. That's why it's a serious event. Have you ever been arrested before?
This is least.
Other than this? Let me tell you, this is just a serious set of circumstances. This is terrible for many ways, but for the vulgar way you spoke and the way you spoke when you were videoing this, it makes it sound like this is something you do regularly, which isn't not part of what the United States of America stands for. You're going to jail. I can put you in jail for 180 days, 6 months. I don't put up with this. Anybody tries to do this, they're going to be sent a message the same way. They're going to jail. This puts us back in time, and that's not where we are. We've progressed. We're better than this. Do you understand? It's a condition of your probation. You're serving 180 days in the county jail.
Your Honor, could I ask one thing concerning that? He's a high school senior graduating in May of this year.
He's being held accountable as an adult under the law, and that's the way we're going to deal with it.
If we could postpone any jail time until weekends or until he graduates, which would be May of this year.
Yes,
Complete his graduation.
this is the problem you have when you do something like this. It fouls up everything, including your education and your future. That's why you try not to make foolish decisions like this. And this is about as foolish as it gets. No, he's going to jail. But there's a shock probation method that the court uses as well. You know what I mean? Okay. But you do this, you go to jail. When are you supposed to be in class next?
Tomorrow.
You're going to report to the county jail on or before 6:00 p.m. Friday. You understand?
Yes.
Or else there'll be a warrant for your arrest and there'll be another charge filed to begin that 180 days. Then I'll see. I'll see what happens before Monday morning. Okay? Have you ever been in jail before?
For this, yes, sir.
For how long were you in?
1 night.
How'd that work out for you? Was that? It's not supposed to be enjoyable. It's terrible, though. The person who was pummeled, what's his status? That person's status now?
He's recovered for as I'm aware. He's submitted his medicals and that's how we got them out for the restitution.
Lower his injuries.
Jaw, his face, I know his jawline was broken and
Jaw was broken.
something with his face, his mouth, facial, head injuries, and jawline.
Head injuries, jaw, facial injuries.
Mhm.
Don't ever speak like that again in public. All of this is stir up trouble. We're better than that. We're supposed to live peaceably together. People who stir up because of race or any other reasons, and this is what this sounds. This is just terrible language. That is not what makes a peaceable, happy place. And that's not what just this county is supposed to stand for, because it stands for better. You understand?
Yes,
sir. See the probation.
This is the probation officer. What was
All right, and we are on the record in the matter of Bert Swihart, 24111.
Morning,
Good morning.
Morning, well, P 30758 on behalf of Mr. Schwemer.
Good morning.
Mr. Swire, Bert Swire.
Okay, very good. All right, so today's the date scheduled. This court set for a revocation hearing. Mr. Swihart was here for probation violation, pled guilty to counts 1 and 2, allegations 1 and 2 in that matter. And then there was some discussion as to the recommendation. And so if I recall correctly, that was another long date for everybody. And so this court indicated we were going to set it back for today's date for revocation hearing. Clearly, I didn't pay attention to the docket numbers that day. But in any event, counsel,
And that is correct. He did plead, somewhat convoluted because there were actually 3 violations.
right,
And the recommendation for those was to revocation of his 769 status, as well as revocation of probation and maximum incarceration. We had, for lack of it, he pled guilty to the count 1 and 2, which was a mistest, I believe, and whatever, I apologize, I don't recall the violation of the notes. And after a hearing, particularly regarding the, to some extent, the lack of a witness on the improper contact, the court found him guilty, as he pled to, of counts 1 and 2, not guilty on count 3. And we proceeded to, I argued that the revocation under these circumstances was not, I believe, was an appropriate sentencing. The court addressed those issues, initially indicated, I believe, that he was to serve 60 days immediately for the violations, and that everything was going to be revoked, etc. After further argument on my behalf, the court then said, well, we're not going to do the revocation today. Reduced the 60 days to 5 days for violation 1, I believe it was, and 5 days for violation 2. He served those immediately. He successfully got through that. And now we're back here to determine whether or not there should have been a revocation, I guess, of the violations, or to end the matter, continue probation.
okay, so let me ask this question, because your client's been in warrant status for 2 years. So, well, let me see here. 1 year. Your client's been was in warrant status for 1 year.
That's correct.
And so, sir, did you complete your outpatient substance use counseling?
Yes, I did that for about 2 years for Lincoln Park.
What
I
a-
paid my fines in Lincoln Park as well. That's why I wasn't able to pay my fines here.
Like Lincoln Park?
Yeah, in Lincoln Park.
Well, what does that have to do with this court?
Oh, that's because I the probation, I was at probation in Lincoln Park.
What were you on probation for in Lincoln Park?
It was
Disorderly person?
loitering.
You were in the treatment court there.
Yes.
Okay. Well, sir, okay, that's not my question.
Oh, I'm sorry.
Did you complete your outpatient substance use counseling?
That's the best of my knowledge, yes.
On this case,
Oh, on this case?
Yes.
No, man, not on this case, no.
Okay,
We-
did you complete your 26-week domestic violence
The courses?
courses?
Yes, so we talked about last time, I started them, my insurance paid for them, because you asked if I had any receipts, and yes, that my insurance paid for them, but that's why I didn't have any receipts, I didn't pay out of pocket. But no, I did not complete them, I did start them though.
But why didn't you complete it?
Because I was kicked off the program, because I worked in Livonia, and I was having trouble.
No, we're talking not.
Oh, here, oh, yeah, well, no, I piggybacked, the court piggybacked off Lincoln Park.
Sir, the domestic violence, 26-week domestic violence counseling that you were supposed to be doing, that this
Yes,
court
yes.
ordered you to do.
Yes, I started, I did not complete it, no,
Why did you not complete it?
I just stopped going.
Well, obviously that's sometimes why people don't complete something. Why did you stop going?
I lacked transportation.
Did you communicate with your probation officer about that?
Yes, ma'am.
So counsel, your client didn't do what he was supposed to do even on probation.
I understand.
So, your client was in warrant status for over a year. So since the maximum penalty, is 90 days jail, why should this court not revoke probation and sentence your client to because he didn't do any of his probation requirements?
Your Honor, because first of all, you've already addressed those issues as what he violated for. If the court was gonna violate him, and now say, now you have to go to jail for another 90 days, that was the recommendation previously set forth. We argued, and I argued that that would not be appropriate. That's why.
Okay, well, what's the legal basis, counsel, for that to not be appropriate?
Well, the legal, there doesn't have to be a legal basis to say that something is inappropriate at the time of sentencing. What I'm.
Counsel, my question is this. I'm considering the recommendation here that was put forth for maximum term of jail for your client, because your client did not comply with the sentence that this court put forth. And the court ordered mandatory jail for any violations.
And Your Honor, there is no, in the charging document, the violation of probation. It didn't say he didn't complete the program. He didn't do this. He didn't do that.
Now that says he failed to register for domestic violence classes.
Exactly.
Right.
But that's what it said. So he failed to do that. And there was also he failed to test, I believe it was.
That's a positive for alcohol.
Right.
Correct.
And those were the two that he pled guilty to and he's found guilty. Oh,
Right.
okay. As you stated, and that's what we did. I argued at that time, Your Honor, you said, well, we're going to revoke everything and give him 60 days. And I said, I believe that the 60 days is inappropriate. That's all I said.
I know that.
And that was the argument. So now,
Why do you believe that
so you sentenced him, Your Honor, to the violations. And if you want to revoke it, that's fine. But, Your Honor, I don't believe you can now give him 90 days. You already gave him 10 days.
Did you serve your 10 days, sir?
Yes.
Yes, ma'am. Right from here, I went straight to Cummings. And I started a new job Monday. I've been looking for jobs. I found one at ATM back then. And I also have a hearing April 9th for my last job that I was at for 10 years. So April 7th, Tuesday, at 1 p.m. at Teamsters, local 362.
Okay. So, counsel, again, my question is this. Your client got the benefit of not being sentenced to jail back in May of 2024 for this conviction, because this court ordered your client to complete certain conditions of probation. So then why, since your client didn't do what he was supposed to do on probation, why should your client get the benefit of not having to do probation and not having to serve jail?
Because, Your Honor, the court, he did some of the probation.
What did he do from probation?
Well, he at least attempted to, he was tested part of, he failed it, but that's neither here nor there, that was a violation. He also started the classes and didn't complete them. That's what didn't happen. So, Your Honor, what I'm trying to say is this court had a hearing, and I argued that the recommendation was inappropriate, and that an appropriate recommendation, even if you're going to revoke his status, and even if you're going to revoke his probation, you gave him 10 days. So it has been solved. He has been punished for failing to do what he was supposed to do. And he served it. So it's double jeopardy. You're double dipping. That's my argument.
Okay, that's your argument. So your client then, on a domestic violence conviction, then, because he did not comply with probation, only serves 10 days jail.
Well, Your Honor, yes, because you found him guilty of those probation violations, and as part of the violations, you gave him 10 days, which I argued for, you gave him 60, and then I argued that that was improper, that this would be a lower one, and I asked for certain things to occur. The court then said, no, this is what we're going to do. We're going to give him 10 days. Now, he immediately left.
Right.
We're going to set it up for a revocation hearing. Well, but you've already punished him for the violations.
Right, I have for those violations, but now I need to determine what I'm doing as far as the sentencing for your client.
No, Your Honor, you can't sentence
In
him.
that regard. Because your client did not comply with this court sentencing. So what I'm going to do, Mr. Swihart, is this. I'm going to revoke your under advisement status. I'm going to revoke your probation. Before I continue with this, you have new charges. The 251636 matter, correct?
No, Your Honor, that case was, I believe,
What happened with that case?
was disruptive behavior. We did that at the same time.
Right. So this court's going to order 60 days jail, credit for 10. I'm going to suspend the 50. You are to complete your domestic violence classes, sir. We'll do a jail review in 2 months to see how you're doing with those classes, sir.
Yes, ma'am.
We can do June 17th, council. You're back June 7th or June 3rd. We can do June 3rd.
Whatever the court.
You're back June 3rd.
Ten.
10 a.m. Okay. You can have a seat in probation so you can get the paperwork that you need from probation. All
Thank
right.
you so
I
much.
think I got it wrong. You can certainly appeal it. That's fine.
Your Honor, I'm wondering what, I assume alone that there are costs and fines due on the case.
Right. So he has to set up a payment plan
That's
because he hasn't done
a
one.
payment plan. I just wanted to make sure the record.
Yes. Okay.
Thank you.
Thank you. Have a good day. This is the matter of City of Wyandotte versus John Stone, 251546. And 24404.
Good afternoon, Mr. T. Spano, P33828, appearing on behalf of my client, Pearson Miller. Take the right name for the records. John Stone.
All right, thank you. Thank you for addressing appropriately for court. Today is the date scheduled for sentencing in this matter. We had, Mr. Stone was interested in treatment court. However, he's not eligible based upon the statute, based upon, one of the convictions on your client's criminal history counsel.
Right, he's here for violence for probation in addition to his sentencing.
Correct.
As to the violence for probation, he's pleading guilty. And Your Honor, basically on getting a new case. Is that correct, sir?
Yes.
And as to, I'll address that when the court's ready.
All right, sir, as to the probation violation, please raise your right hand. Do you solemnly swear from testimony about to give in this matter, the truth, the whole truth, and nothing but the truth?
I do.
All right, and sir, you heard the plea, or that you did the allegation, and as to that allegation, how do you plead?
Plead guilty.
And you've gone over your advice of rights for probation violation purposes, correct?
Yes, ma'am.
And you understand all of those rights.
I do.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am.
And you also understand the possible penalty as a result of your plea.
I do.
The recommendation in this matter for you to serve 30 days jail, revoked, we should revoke under advisement, say that's correct.
Yes, you.
And knowing all that, do you want to continue with your plea?
Yes, you.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, if you can please go to your client.
Mr. Stone, you agree that you are on probation to this court on the charge of domestic violence?
Yes.
And the victim in the matter was your wife, correct?
Correct.
She's here today, isn't she?
Correct.
Right, and you've had reason to spend some time in the probation department doing the things you were told to do, correct?
Yes.
One of the things that the court specified was that you get no new charges, criminal charges. Is that correct?
Yes.
In fact, you got a charge of public intoxication in this court. Is that correct?
Yes.
So you agreed that you violated your probation by not complying with that court's condition?
Correct.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. And counsel, I can address the sentencing on that as I'm addressing the sentencing on the public intoxication charge that your client pled guilty to. Did you have an opportunity to review the report and recommendation with your client?
I'm sorry, Your Honor. What client was asking a question? I'm sorry, what was that?
Did you have an opportunity to review the report and recommendation on 251546 with your client?
Yes, Your Honor, it's accurate. My client is 39 years old. He lives with the mother of his children, 2 kids. She is present in the courtroom, Your Honor. There's been no other violations. My client presently attends team wellness voluntarily. He's admitted that he's got a problem with the alcohol, Your Honor, and that's why he's here. As far as the under advisement status, we would hope that the court would reconsider revoking the advisement status, being that he's back with his family now. There's been no assaultive or other contact for the police to be called. Your Honor, he works full-time and the busy season is coming for the job that he does. He works for a landscaping company owned by his brother. So he would hope to keep his job. He would hope to keep his place and family. I know that the recommendations is some significant jail time. Your Honor, we ask the court to consider either alternatives to jail or no jail at all and put him back on a probation period with perhaps some more harsh or some additional, let's put it that way, conditions. But I told my client sentencing is 100% in the court's discretion. He will need time to pay some additional fines and costs, Your Honor. He's been, other than that, he has nothing else pending, no bench warrants, no holds on him. Is that correct, sir? Yes. With that, but even the court's discretion is to sentence, Your Honor.
All right, so,
Your Honor. Do you want to say something?
Yeah, I want to say something.
okay,
Don't reach out to me and let me know that I wasn't eligible for the alternative sentencing that we did previous, for the sentencing on the public intoxication. So that's news to me. I never heard that. And I'm sure you recall, but I guess just to refresh the court's memory, the reason that I'm so adamant about being able to be out for this next period of time is my youngest son's graduation. So I'm sure, I don't know if you do recall that conversation, but my youngest son's graduating from Roosevelt High School as a senior, and that was why we were looking at other possibilities.
Possibility to jail, correct?
Yes.
well, right, but at some point, Mr. Stone, I mean, even going back to 2018, okay? Well, even 2003, you have matters involving alcohol. 2018, but I don't know if in Massachusetts alcohol is involved or not, I don't know. In 2018, assault and battery. 2018, fleeing and elude, 3rd degree. 2019, 21, there's 2 in 21, driving while license suspended. Then another one in 21, disturbing the peace. Disorderly conduct in 22, disorderly conduct in 24, and then 24, domestic violence. Now, we have public intox as well. And, sir, you've been here almost as often as I've been here in the last 7 years.
And that is when I started having problems with alcohol.
Right,
Yeah.
right. And then you do well when you're on the alcohol tether.
Which I'm currently on and
Right,
doing well, for a good
right. But
portion.
here's the thing.
Yeah.
Right? The purpose of probation is so that an individual can have the opportunity to participate in programs or conditions that will give them tools to not reoffend. So, in a number of these cases, sir, you've had probation and you're continuing to reoffend. Continuing to reoffend. And so you're not a candidate for probation at all.
Your Honor, they rejected him in the right of court, so.
Because not because he doesn't have the need, but because there's prohibitions based upon
His record.
his record.
I understand.
One of the convictions he has on, 2 of the convictions he has on his record. It automatically makes him ineligible.
I understand. That's.
When I referred him for that, that was my misunderstanding. I thought there were certain convictions that are discretionary by the treatment court judge. That's not one of them.
I understand, Your Honor. That's why I mentioned that he's attending team wellness now. Is that correct, sir?
She knows I have been since the probation stipulated it, all these years ago. I also, once his charge was picked up, before I got sentenced to probation, I checked myself into Sacred Heart in Richmond voluntarily, did the 2-month in-house treatment, graduated that. And yeah, this disease is a battle. I mean, all this time I was on probation, and since the day I picked up the charge, I wasn't on an alcohol tether. I stayed sober because I needed to and wanted to. And throughout that time, I've gained, at the time of this charge, I wasn't even living with my family. There were stipulations I couldn't go home. They didn't want me. And I gained all that back without a tether and, through probation and other resources, but because I wanted to. And
I understand. So what happened for this public intox case for you to pick that up? Why did you relapse?
I really don't have an answer for it. I can't place it. I think about it myself, like what triggered it. I can't put it on one thing. I was
out of work for the season.
Which, sir, you know your work is seasonal, so then line up work for the off season so you don't
Yeah.
have that downtime.
No, it's exactly what I should have did, but that wasn't the case, and I can't, point at one specific thing that caused this relapse. I wish I could, so I could address it, but I can't think of one specific thing.
That's why I say that some type of other intensive outpatient treatment or the like might be more appropriate. He's not gonna get any help in jail, Your Honor. The court knows that.
Well, that's not true. He can be covered to treatment through the Wayne County Jail. So
True.
there is that, counsel.
Is that.
Here's what I'm going to do. I'm going to order on the 251546 that there's not reasonable grounds to depart from MCL 769.5. The court's going to order 90 days jail to be served on the Wayne County Jail alcohol tether. If there's one violation, sir, you're serving the rest of that tether time in the Wayne County Jail.
Yes, ma'am.
And then on the and then on the 24404 probation violation, the court's going to order probation or revoke probation, revoke under advisement. The court's going to order 30 days jail to be served on an alcohol tether. That's consecutive with 251546. So you're going to have a total of 120 days
On alcohol tether, correct?
on an alcohol tether. Sir, this is the best scenario for you without sentencing you right to jail.
I understand. Okay.
I know how much better you do on an alcohol tether. At this point, this court can't sentence you to life on your alcohol tether, right? So you're going to have to continue to utilize your treatment and your coping mechanisms to work on what happens with your triggers. If, sir, there's a violation, you're automatically serving the balance of the 120 days in jail. There's no hearing, nothing, nothing.
I understand.
So just so you're very much aware, sir.
Well, certainly, Your Honor, my client's entitled to a hearing if that occurs by right.
If he contests the test result, then yes, he would have to schedule a hearing. He'd have to request a hearing. But if there's a violation, then and that violation is your client consuming the alcohol, then you're in custody for the rest of the 120 days, sir.
You understand, sir, that pretty much you've got the jail cell keys in your own pocket.
I understand.
If you drink, you violated, you put yourself in jail. Do you understand that?
Thank you, Your Honor.
Good luck to you, sir. Stop over at probation and somebody will be with you shortly. Can you hand me those, please? So go off the record for a quick moment.
Thank you.
Let's go on the record in the matter of the City of Wyandotte versus Leonard Rylett, 26375, 25883, 25751.
Good afternoon, Your Honor. Neil, on behalf of the defendant. Mr. Roulette, can you hear us? Could you please state your name?
You need to unmute, Mr. Rylett. Mr. Rylett, you need to unmute.
Hello?
Hi, your name for the record, please.
Leonard Allen Rylett.
Okay. And, counsel, Mr. Rylett's here to handle all these matters.
Yes, Your Honor.
Board's quite familiar with Mr. Rylett. I know that you're very unhappy in that regard. But here we are nonetheless.
Yes, Your Honor. In fact, there are 3 matters before.
Yes.
Excuse me.
All right. And so, as to the pretrial in these matters,
Yes, Your Honor. I've had opportunity at some long discussions with Mr. Rylett as well with the city attorney, and we've reached a global resolution on all 3 of these matters. I'm going to do my best to keep them in order. Alphabetically or numerically, I guess. Case number 25, see if I had these in the right order. Here with me, Judge.
25751 is first numerically, if that's
5751, Your Honor. Client's prepared to plead guilty to an amended charge of attempted possession of controlled substance. The other 2 offenses would be dismissed, counts 2 and 3. With respect to case number 25883, I will be pleading guilty to the amended charge of attempted possession of paraphernalia. With respect to the 3rd charge, case number 26-375, be pleading to an amended charge of guilty to attempted possession of paraphernalia.
wow. Mr. Rylett, your attorney did a really good job for you here. I'm not really sure how it is that you qualified for all these reductions, given
I think-
your extensive criminal history.
I thanked the prosecutor and the judge, and I'm just in a bad way. I just had
Hold on,
serious
pause,
surgery.
Pause. You don't have to worry about thanking me at this point because you don't know what's happening next.
I don't know.
You're correct. You don't know. And so, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. And you heard this extremely generous plea that your attorney worked out for you, correct?
Yes, I did, Your Honor.
All right. As to case number 25751, attempt possession of controlled substance, how do you plead?
I plead guilty, Your Honor.
As to the case 25883, attempt possession of drug paraphernalia, how do you plead?
Guilty, Your Honor.
As to 26375, attempt possession of drug paraphernalia, how do you plead?
Guilty also, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
Yes, I do.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency, correct?
Yes, I believe I do.
Okay. And knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor, it's the truth.
And any immigration issues?
No, Your Honor.
All right, and counsel, if you can please audio your client.
Yes, I will. Mr. Rylett, you recall being in the city of Wyandotte on about the 28th of May, 2025?
Yes, I did.
And at that time you were on your bicycle, you had an interaction with a Wyandotte police officer. You recall that?
Yes, I do,
During-
Counselor.
During that interaction, you had on or near your possession, you had attempted to possess a crack pipe, which is a device used normally for smoking illegal drugs. Is that correct?
I did, yes.
And then on subsequent date, that would be June 20th, 2025, you were also in the city of Wyandotte at that time and had another interaction with the Wyandotte police officer. I think you were on a bicycle at that time too. Is that correct?
That's correct, Your Honor. I mean,
Yeah,
that's
during-
correct.
Thank you. And do you, at that time, it was determined that you had on or near you or under your control, you attempted to possess a crack pipe.
Yes, I did.
And more recently, on May 20th, you were in the city of Wyandotte and you had an interaction again with a Wyandotte police officer. Is that correct?
Yes,
During that interaction, it was determined you had in the vicinity of you, there was a crack pipe that you attempted to possess. Is that correct? I'm sorry.
yes, I did. Yes.
Your Honor, I need to correct the record.
Okay,
25751. The plea is to controlled substance, I think.
correct.
If I can read. I'm sorry, Mr. Rowlett, I have to revisit the earlier case. With respect to the incident, the first incident that we talked about on May 28th, you, in fact, when you had that interaction with the officer, you had in your vicinity, you had some crack cocaine, or you attempted to possess some crack cocaine. Is that correct?
That is correct.
Sorry about that. Getting back to the more recent case, 26-375, that case, you attempted to possess a crack pipe.
That is correct.
Okay, Your Honor, I'm satisfied with that.
The court is also satisfied the plea is knowing, voluntary, and factually accurate as to all cases. Will accept your plea to the amended charges, dismiss the original charges on these matters. And counsel, as to sentencing.
Mr. Roulette, I'm sorry if I may address Mr. Roulette, Your Honor. Mr. Roulette, the judge is offering to immediately sentence you as opposed to sending you to probation for a pre-sentence investigational report. Do you want her to do that? What is your position with regard to that?
See your sons.
I'm sorry, we can't hear you.
Are you talking to me?
Yeah, yes. The judge is suggesting that she can sentence you immediately. I want to know from you whether you're prepared for sentencing today. Don't ask me what she's going to sentence you. I can't possibly know that.
Well, I guess I'm ready today, Your Honor. I just had a bad surgery though in here 3 days ago.
You had surgery?
Yeah, of all things, they said a brown recluse spider got me in here, and they cut an abscess out the size of a shotgun shell, and I got a big hole eating tissue through the back of my quad of my leg right now. I'm not doing very good. I just did 9 days before I was picked up on this stuff. I got 13 days in now. And prior to this stuff, I did have a perfect reporting report with you. I made it on tethers and everything. If I could ask this for that chance, only because of my health right now, I'm not getting the best change of my wounds in here the way it should be. I know it's jail, but at my age right now, I'm really concerned of all this stuff. I got a bad infection going on here.
Well, sir, since you brought it up with your age, you're way too old to continue in this cycle, Mr. Rylett. Way too old.
That I
to continue in
understand.
this cycle. Your criminal history, Mr. Rylett, goes back decades. Decades. And then you're
starting to make
continuing to
help.
get in trouble. You're continuing to violate the law.
I had team wellness set up on my own prior to this arrest, knowing that I need something like that to structure. I did get some benefits out of your program, and there was some setbacks too. But I knew with something like that in place, a structure, it could give me a chance to go in a direction. I was almost done with all these warrants to the point where I could have got my license back and had some upward mobility. You know, I had goals going on right now of that type of stuff. And I knew mental health was going to be a catalyst to help me get to that. When I was with your court, I never got the drugs not once. There was always a problem with that. Even Bobby knew about that. Team Wellness had me on a track to where I was going to start to get my drugs, see the psychiatrist, a therapist, all like condensed in the same day. I could see it, and it wouldn't be so difficult to get there 5 times a week on a bike or a bus. but I was still willing to do whatever it took. I'm still willing to do that. I need this, I don't need cocaine to help try to medicate me into an endorphin of good state of
Well, you're
mind.
saying, Mr. Rylett, you're saying that, but all three cases that you have here have to do with cocaine or crack.
I'm
also,
asking, I know that I
also,
need to
please
change.
please stop. And also,
Okay.
you just did 90 days. You were out for less than 2 weeks and you were arrested again.
Okay,
Mr. LeBlanc, what would you like this court to know?
that's fine.
Well, Mr. Roulette's covered pretty much everything that I would have mentioned. You have, Mr. Roulette's history. He sought help. He's apparently been in the treatment court before. Over last year, he discussed said he had an appointment with Team Wellness a few days later, but I was unable to keep that. So I guess that not much better. Don't make their medical condition. There's some treatment available from there.
Well,
A short leash is all I ask for, Your Honor.
short leash is too much of one, quite frankly. Your criminal
Okay.
history goes back to 1979, sir.
Okay,
1979. That's almost 50 years.
all right.
And in
Well,
almost
it'd be
50 years,
up to
sir.
me.
Excuse me. In almost 50 years, sir, you've had jail terms, you've had probation, you've had lots of options, you've had lots of opportunities that you've not availed yourself of. You've had misdemeanors, you've had felonies, you've had a lot of variety, sir. A lot of retail frauds, and then there's possessions.
I understand.
Attempts.
I did a lot of time for all that, and I have a mental illness, I found out. I understand.
And it's not even in one court, it's multiple courts. And you have, and in fact, you,
I did.
sir, upon your release from your jail term from the 28th District Court,
Yeah,
then you ended up getting in trouble for retail fraud in Van Buren in the 34th District Court. And then
Right.
here. So,
I'll-
I mean, listen, at some point,
that's fine.
this court can craft a solution that would, assist you moving forward. But sometimes there are just individuals that just, do not want to avail themselves of the assistance that they get, or opportunities that they have. So this
Okay.
court's going to order 45 days jail on each case to be served consecutively.
Oh, can I add the plea withdrawal? How can some happen on the same day, Your Honor? Two cases
Excuse me.
happen the same day.
Sir. 25751, the offense date was May 28th of 25. The court's ordering 45 days jail. Case number 25883, offense date June 20th, 25. The court's ordering 45 days jail consecutive with 25751. And with 26375, that offense date was March 20th of 26. That's 45 days jail consecutive with 883 and 751. So that's a total of 125 days. The court will give you credit for let's see, that's been, let's see.
Can I withdraw this plea?
The 11 days.
It should have been 13, but can I withdraw the plea? Because I wasn't informed about the way the time would run. And set this for like all 5 jury trials.
It is 13 days. I was looking at the wrong calendar. So you have credit for 13 days. Well, counsel, I can have you go speak to your client in the breakout room since he wants to withdraw his
I
plea.
need to withdraw it. I didn't know about the time, how it's gonna run like that, consecutives.
Well, sir, the
Two
court has
cases,
discretion.
cases
Excuse
were on
me.
2 cases were on the same day.
No, sir, not in this court they weren't. But
Well,
let me
they
just
must-
clarify, Mr. Violet, let me clarify
Okay.
something. The court has discretion
Yeah,
as to whether or not to sentence jail time consecutively or concurrently.
all right. Well, all right. I
So
didn't
you
understand.
can,
the
you'll have a
plea.
chance to speak to your attorney in the
Thank you,
breakout
thank
room.
you, thank you, thank you.
You're welcome. Okay, so Mr. Eilert, please unmute. All right, we are recalling the matters of the city of Wyandotte versus Leonard Rylett, 26375, 25751, 25883. And appearance, counsel?
Yes, Your Honor, all these matters, Neil LeBloy on behalf of Leonard Rylett. Mr. Rylett, can you state your name, sir?
Leonard Allen Rylett.
All right, and so the court had accepted the pleas for Mr. Rylett on all three matters. And then the court was imposing sentence, and Mr. Rylett wanted to potentially change the course. And so the court put Mr. DeBloy and Mr. Rylett into a breakout room. And Mr. DeBloy?
Your Honor, yes, here's the dilemma. Mr. Rylett insists on moving forward with a motion to withdraw his plea. I assured the court that I advised him of his rights and potential penalties, and that was placed on the record. Other than the question of whether or not he has competency to understand his decision-making process, I have no insight into that. I can't ethically advance a motion I don't have anything to move forward with. He's indicated to me that he's dissatisfied with the service, but not accepting my position in this. And I believe there's an ethical problem here. It's a breakdown of the relationship between he and I that either can't understand or refuses to understand my position, my legal advice to him. He wants to, I advised him that if he wants to proceed sans counsel, he can do that. If he wants to make a motion to withdraw, I certainly have no, certainly can't stop him from attempting to do that. But what it boiled down to in my additional discussions is that he expresses extreme dissatisfaction in the services that he's being provided. And so he may want to seek other counsel. Is that correct, Mr. Rylett?
Yeah, I wasn't aware of how, I know how you told me the attempt. It was given a deal from attempt to the regular, whatever it was, attempt, down to attempt. And then when Judge DiSanto was taking my plea on record, she says, do I understand the amount of time everything carries? And I said, yeah, but I really wasn't advised of what it did carry. And then to be, for it all to be consecutive, that was the surprise to me,
Okay, so sir, the answer to the question is yes.
Did me and him have a breakdown?
The question was that accurate? Was that an accurate recitation of the understanding as to what was happening? That was the question by your attorney. And your answer is yes, correct?
Yes, I believe I understand that question.
Okay. And so you want to move forward with setting aside, you want a motion to set aside the plea. Mr. DeBloy has stated to you that there's not a basis that he can ethically put that forth to the court. And so he's wanting to withdraw from representing you because there's been a breakdown of the attorney-client relationship.
Yeah, the only problem I had was I wasn't advised of what that could carry, the time that could carry, the way it was after the plea arrangement.
Sir, let me just be let me be clear. The maximum penalty, I'm sure the maximum penalty was explained to you as far as it being 45 days jail or probation or a combination of both or fines and costs. This court has the discretion as to whether or not a sentence is consecutive or concurrent. So whether
That wasn't
or not,
explained to me. That part was not explained to me.
sir, there's judicial discretion in a whole array of
Okay.
formats, that being one of them. So the court will note that the plea is not accepted, that there's been a breakdown of the attorney-client relationship. And sir, so as this court was going to sentence you to 120 days, just so you're aware, sir, the pleas have all been set aside, so now now the original charges on all these matters, which are up to 90 days jail, each of these matters is back on the table.
I thought you said it was more than 120 days before.
Maybe it's 125 days, wasn't 45, 45, and 45 is 125 days. Plus the third, with the 13 days credit was gonna be less than 120 days, but, oh, 135. Okay, yeah, sorry.
Oh, see, I'm.
We're gonna set this for a new pretrial date with a different attorney.
Okay,
Grant Mr. DeBlois motion to withdraw based upon the breakdown of the attorney-client relationship. And we need to make sure we've received the documentation from Mr. Hyder's office on Mr. Pruitt.
yes,
Oh, okay, sorry about that. You got pulled back into a room inadvertently. So the court is granted Mr. DeBlois' oral motion to withdraw based upon the attorney-client breakdown. And the court's going to adjourn this to April 15th at 8:30 a.m. with a different MIDC attorney. Bond and conditions are continued.
thank you then. Thank you.
You're welcome. Have a good day.
Yep, April 15th.
Tuesday.
Thank you, Wayne County Jail.
Court does call the case, People versus Orange.
Morning, Your Honor, Raymond Cook for the people.
Phoenix Saxon for Phoenix Born. He's the attorney for the court.
Phoenix Born. All right, you're asking for an adjournment.
I am, Your Honor, I have a bond argument.
All right.
Your Honor,
I will adjourn the matter April 6th, 2026, 9 a.m.
also
Bond.
April
16th. Bond.
Your Honor, Mr. Boers was arrested for being outside of the home and was on a house arrest with GPS tether. The reason he was outside the home, he was still in the same complex. And this was relayed to me by his mother. She forced him to leave because he lives in her house, has to follow her rules. His cousin died and they were doing a balloon release in the complex. And she, despite him saying, you know, I'm not allowed to leave, she was like, get dressed, get out, and let's go. Repeatedly, you're in my house, you follow my rules. And he did it. As the map shows from non-compliance or GP, he sincerely was, he really was not far from his apartment. And that is the reason he was not hanging out. And given the time shown from departure to return, it's lined up with the fact that it was a few minutes, the balloon release, and then he came back home. He did not go anywhere else, and he was on foot. So this is his first offense. He's 18 years old. He is a student. His mother also confirmed for me he is still in school. I'm waiting for a letter from the school showing that upon completion of this one exam, he will be finished as a senior and he would be able to graduate. So I'm asking for his bond to be modified to a personal bond with him remaining on the GPS tether. And now his mother has full understanding of what house arrest means.
How come he didn't respond?
I'm sorry, Your Honor?
To respond when alerted. Why didn't he respond when alerted that he was in the zone? I mean, they send warnings and notifications and attempt to try to contact, and there was no contact.
Again, it was, you're going to be here, we're doing this release, period. It sounds quite cliche, I'm not being sarcastic at all. He was caught serving two masters at this time, the law and his mother.
Your response from the people.
I would leave this up to the discretion of the court. Certainly, I haven't been able to have contact with the father or confirm whether or not. Yeah, actually, does come out. I trust counsel at her word, and if she spoke with the mother, I trust her on that. And those representation is made to the court. I'll leave it to the court.
I do have the text messages from the mother that I'm willing to show prosecutor in the court. And but for transportation issues, she would have been here this morning.
And looking over the report, I guess he was out. Well, maybe 10 minutes, but given that explanation, I'll grant the motion for a bond modification. His previous bond conditions, including the bond, is restored. All right.
I did have one additional matter with the defendant's bond being restored. I know the court sessions for April 16th. I'm requesting to get just a little bit longer than that. I anticipate there being additional reports forthcoming, and I don't know how long it's going to take to get, because I just don't want to be in a back on 16th. We still don't have all the discovery orders.
Got it. Any objection to that, count?
No, Your Honor.
I'll go to the 30th.
Thank you, Your Honor.
2026-90. Ron, can you, thank you.
Thank you.
All of it. Court calls case, People versus Troy Swope. Goldstein.
David I. Goldstein appearing on behalf of the defendant.
Troy Swope. All right, what are we doing?
Your Honor, in this matter, I had spoken to Mr. Chavalowski about a resolution that I was planning on discussing with my client this morning. But as I think the court is aware, there was something intervened which prevented me from being here this morning. So I'm asking for a 1-week adjournment, but we did also address bond last week. And you indicated you wanted to see some proof or some information regarding the Suboxone regimen that he is on. I attempted to provide that to the court this morning by Zoom. Your clerk indicated, however, that it may not be readable, and if so, I can read it to the court.
It's hard to.
Yeah, my copy is a little better, Your Honor. I might be able to read it to the court. Basically, it came from Trinity Health, the group recovery medicine. They confirmed that he is on Suboxone, and they are monitoring him. There was a period of time when he was, because of his insurance problem, that they were unable to provide it, and that was when he relapsed. But he is back on the Suboxone, and they are monitoring him. And that's coming from Francis Michael James at the Trinity Health IHA Medical Group Recovery Medicine.
Okay, I don't know why Bellinger has it, but I got a good copy. He's just, because Bellinger's in everybody's business. I actually have a very good copy that I can read. You know, and it's funny, Mr. Goldstein, while he watched us old people struggle to read it, Bellinger got the good copy right here.
You're welcome, Mr. Goldstein.
Johnny on the spot, or say Jay on the spot is what I should say.
For the chip report, there's his attention. Right, but this is not indicating that he's back in treatment, right?
One moment, Your Honor. I've got to address something real quick. I'll be right back.
From home, I mean,
Yeah,
do you need some music?
yeah.
back, Your Honor.
You know, you're the only one that would ever be able to get away with that. All right. This does not indicate that he's in treatment, however. It indicates that there was, but if I'm reading it correct.
Okay, is the one you have dated April the 1st, Your Honor?
It is.
Okay. I mean, it
So
does say his
basically what
history.
it's telling me is that he reestablished connection to the clinic on February 25th. However, they're unable to comment on his compliance, given that he failed to follow up with the urine screen ordered on that day.
Your Honor,
So
that's,
it does,
so
he's in
there's another
compliance.
document. I'm sorry, Judge. There's another document that I have that indicates that he did appear but didn't have the money. That's why it was not completed.
Is that
This is also for Mr. Bellinger.
Mr. Bellinger has that one too?
Yeah. I
Okay,
don't know
hold
if
on.
Mr. Goldstein has.
No, Mr. Goldstein is reading from his phone. I don't know why Bellinger has it muted.
Your Honor, his family's here and have.
Oh, and they're handing you stuff? Why didn't you tell me that?
Your Honor, I didn't.
You just were making it look like you were doing something. Hold on one moment, man. All right. Yes, ma'am. What's your name?
States that we didn't have the $400 for the drug testing that day, but if you look, we did reschedule it.
When is it rescheduled?
I don't remember the exact date. I went to the clinic today and they wanted it to show like we didn't have the $400 for it and we needed to do that.
Okay, so I get it. So there was an insurance issue. You had to pay it out of pocket, which was 400. You didn't have the 400. It's not like you didn't have $25 for testing. You didn't have $400 to follow through because of insurance. All right. Thank you, ma'am. What is your name? Because I have to have it on the record. Your name's Emily? Will that work for you? Okay. And your relation to, really? You're smiling about it. Oh, okay, never mind. What? Look at who? That's mom? Who's mom? That's Mr. Swo's mom? Okay. You like her? You do? Okay. I was just being nosy. It has nothing to do with my decision. So, what was his previous? Mr. Goldstein, what was his previous bond set?
Your
I
Honor,
think he was on
I don't have the file with me.
5,000 PR.
Yeah.
And then to comply with treatment. So what I will do, I'll grant well, we got to set this out. You want this set to what date, sir?
Next week, Your Honor. Next Thursday.
I'll set it to April 9th, 2026, 9 a.m. I'll reinstate the defendant's previous bond of personal recognizance, $5,000. Follow all treatment and everything. You understand that, young man?
Sure.
Yeah. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case, People versus Wardell Smith.
Morning, I Rob Wardell Smith, who's approaching the podium. Wardell, would you state your name for the record? Wardell Smith Jr. Judge, this is a PCC matter. I've had a chance to speak with Mr. After discovery. We're asking you to sit for an exam.
All right, preliminary examination will be set for, will the people have their witnesses available the 14th? Set preliminary examination, April 14th, 2026, 9 a.m. That is before Judge Moore.
Judge,
Yeah.
may I address bond?
Well, both of you want to address bond.
I think I should go first.
Why is that?
Because I know what she's gonna say, so I want to beat her to the punch.
Okay. Go ahead.
Judge, no, not to be facetious, but my understanding he's got a $50,000, 10% bond. This is incident between he and his wife, a long-term marriage. My client is asking that if the court would consider a $5,000, 10% bond tether if necessary. He's the sole support of the family. He will stay away from the marital home as for now and wants to help work with his children. His daughter's graduating this soon. He wants to be able to be there. So what we're asking for is a reduction in bond.
Response, I guess.
My attention that Mr. Smith has made, I believe, my last check was 65 calls to the victims listed, number which we have had contact on correctly before from his pin since being arraigned in the jail. I and for phone privileges and text privileges to your votes in those calls. There terms of giving I love you, babe, things like that. So it's a pretty good idea that it's Mr. Smith and would have to your vote this time for bond remain set, given that he has violated that bond.
Judge, if I may, I thought when I got the appointment, I was told he was out of custody. I did call the one number. It ended up being his wife. She then texted me saying that she would like him home. I told her I can't speak with her anymore about that. That's something for her to discuss with the prosecutor. But again, Your Honor, we're asking if you would please consider a reduction of bond on tether.
I'm going to deny the request. He's violating the conditions of his bond. Or at least an indication that he has. So I'll deny the request for any reduction in bond. Bond will continue. Defendant's phone privileges and texting privileges are hereby ordered revoked pending a hearing. Thank you. He's in Zoom?
Yeah.
Okay. Court does call the case. People versus Orby Huffman. Your name, sir?
Orby Byron Huffman.
All right. And Mr. Huffman, you're intending upon representing yourself?
Yeah.
I'm sorry, you said what?
Yes.
All right. I do have to again apprise you that you are before the court on the charge of assault of a prison employee. You understand that charge?
Yes, I do.
That is a felony punishable by up to 5 years incarceration, a $2,500 fine plus court costs. You understand that, sir?
Yeah, I hear you.
You understand that there are difficulties when you are representing yourself, but I need you to be apprised that the court will treat you the same, as you won't receive any worse treatment, you won't receive any better treatment. You understand that?
Yes, I do.
And you also understand that the court will presume that you have knowledge of court procedure and court rules. You understand that? The court will not be in a position to assist you regarding any of that. You understand that, sir?
Yes, I do.
Do you still intend upon representing yourself?
Yes, I do.
I do have to also tell you that if at any time you change your mind and you wish to be represented by counsel, you just need to inform the court and the court will ensure that counsel is appointed to represent you. You understand that?
Yes, I do.
All right. What are we doing on this case?
I would indicate, I've just been informed by several of my colleagues that Mr. Orby was before Judge Conlon yesterday on a case where he's represented by David Burgess, referred for a competency evaluation.
Oh, he was referred for a competency in that case? All right. Given that, would the people be requesting that I refer for competency on this case?
Because at this point, there's a question with respect to his competency, and we need to know that he is in fact competent before we vote.
Mr. Huffman, anything you want to say regarding that?
I cannot hear what he said.
What he indicated is that you were before Judge Conlon, that you were referred for competency on that case. And that then a hearing was set. I then asked whether or not the people would also be requesting, given that information, that you be referred for competency on this case to make sure that we can proceed forward. The people have made that request. I then asked whether or not you had a response to that.
I feel like I'm capable of representing myself.
All right, thank you, given the information that has been provided regarding a competency evaluation, the court will order on the people's request a competency hearing, a forensic evaluation. I'll set a competency hearing for July 2nd, 2026, 9 a.m. And Mr. Childers, I will need an order. All right. Bond will continue. Thank you, Mr. Hoffman.
What is bond?
I'm sorry?
What is my bond?
Your bond in this case, as set, is $50,000 cash surety.
Is that 10%?
No, it is cash surety.
Thank you.
Thank you. Court calls case of the people versus Cameron Larry.
Alexander, on behalf of you, Your Honor.
Assistant Select Senator Don P. Lebo on behalf of Mr. Larry.
Name?
Cameron Larry.
Thank you. You're looking for an adjournment?
I am, Your Honor. We're requesting some media.
You may.
Your Honor, came to my attention, while the defendant was in custody, he made 3 calls to the victim from his PIN to her listed number. In those calls, he says things like, I'm in jail for 3 days, I've been here every day, what his bond is set at. He also states things like, we really can cut all that shit out. We can go our separate ways. Do not send me to jail. I would not put you here. I know you still got some type of love for me. You're not gonna press charges, but I know you really don't want to see me rot in jail. Might not want to be, might not want to talk with me, but I don't believe that. Right, so you're about to keep me in jail for real. You're gonna send me to jail for 10 years. Me writing you in your on your face, that was just childish. I apologize. Talking about the case, talking about you're gonna keep me in jail. Are you really gonna press charges on me? And so at this point, I'm gonna ask him if you're man he violated his bond. He's called for an after he was arraigned and told not to have contact with her. And he did have contact with her, talking about the case, talking about keeping him in jail and like that. So I have concerns and ask him to hear me that started to violate his bond.
Response, Mr. Allen.
Your Honor, Mr. Larry's indicated to me that these calls would have been made prior to the arraignment. I understand.
It would have been made prior to his arraignment?
That is what Mr. Larry's indicated to me. I haven't been able to verify that myself.
What's the date of the calls?
And the calls are from 26. Along with one on 325 that was later in the evening. After he would have been arraigned.
I did discuss it with Mr. Larry. He does understand that.
Still want to keep representing to the court that they were made prior to his arraignment?
Sure.
What?
Oh, Your Honor.
Yeah, because that wasn't true. All right, go ahead, counsel.
Your Honor, all I can say is that Mr. Larry did indicate to me that he believed they were prior to his arraignment. I'm glad that he's.
Seriously? No, he didn't.
I'm glad.
Just saying that.
Yes, I'm glad.
Just got you to just say it.
Yes, and I'm glad that he's now come clean about that. He certainly understands that he cannot have contact.
She has to check any text. Wait a minute.
That's not help.
Anything else?
I have nothing to add, Your Honor.
People's motion to modify bond. It's granted. Defendant's bond is hereby ordered revoked. Defendant's remanded back to the Washington County Jail Court. They will also order that his phone privileges and texting privileges are hereby ordered revoked. Defendant's remanded.
Thank you, Your Honor.
And we got another one who's going to be spending his Easter in jail. Ladies and gentlemen, thank you very much for hanging out with me today. It's been amazing. You guys in chat, you're the spice. You're the spice of life. Northwest, thank you for being here. Muddy Magnolia, thank you for being here. I'm not sure who the person who won the Judge Boyd election was, but I can tell you this much: they won the Judge Boyd election on the matter of streaming. So we can expect to see that court go bye-bye in the future. I fully expect, because one of the big arguments in that whole election had to do with taking umbrage with how Judge Boyd streamed her court. Maybe they'll still be streaming, but it'll change. Who knows? But we started things off with a PPO, with a personal protection order in Thurston County on the 30th, and we worked our way all the way down to Judge Simpson on Thursday this past week. We didn't have a lot from yesterday because yesterday was Good Friday, and we watched a lot of what there was from yesterday last evening, because we do this every single night of the week. Y'all don't know, where we watch the best cases of the day at 8 p.m. Central Time, 9 p.m. Eastern Time. Come on by and hang out with us. We'll be doing it again all next week and for the foreseeable future. All you guys, I want to say happy Easter to everybody who celebrates it out there. Legal Keys, Julie Sass, Shiloh, Phoenix, Meridian, Muddy Magnolia. How many of these names have I already said? Kirnoff, I said your name. Marty. God, I'm glad you stayed. You guys, Mama Wolfie, Rhonda, wherever you may be, y'all have a great Easter weekend. I'm sure we'll be having a lot better Easter weekend than a lot of the people we saw today. So, until this evening when we have a premiere at 8 p.m. and another live chat, I will be seeing you. I'm your lone wolf Puzzle. I'm your humble curator for these here videos. I am out. Oh, and real quick, shout out to our friends at Law Nerds Unite. Zach, I see you out there. Thank you very much for your donations today, buddy. You rock. All of my lurkers rock too. Lurkers are the spice of life. I lurk in so many different places all the time. Especially like with Colin, Hut, Old Bush Garden, Mike, Lurkers Unite, Court Watchers Unite. You got it. Later. And while you're having a fun Easter break, remember a little movie we like to call Ferris Bueller's Day Off, and how after everything was over, he said, "Why are you still here? We're done. Go away now." But before you go away, last little thing, remember, Easter is the only time of year when it's okay to put all your eggs in one basket.